statute regulates the issuance by the pretrial chamber of a warrant of arrest. Pursuant Article 58(1)b of the statute, a chamber assesses whether the arrest of a person appears necessary. 1, to prevent a person from not appearing at trial. 2, to prevent a person from obstructing or endangering the investigation or the court proceedings. Or 3, where applicable, to prevent the person from continuing with the commission of that crime or a related crime which is within the jurisdiction of the court and which arises out of the same circumstances. In accordance with Article 60.2 of the statute, the person subjected to a warrant of arrest under Article 58 of the statute may apply for interim release pending trial. The pretrial chamber's ruling on such an application under Article 60.2 of the statute is provisional in nature, to the extent that it will be periodically reviewed at least every 120 days or at any time following a request by the detained person or the prosecutor, if satisfied that the circumstance so require. The pretrial chamber may modify its initial ruling on detention, pursuant Article 60.3 of the statute and Rule 118.2 of the Rules of Procedure and Evidence. Regarding the first ground of appeal and the question of whether the pretrial chamber erred in law by relying on hypothetical and non-specific risks to find that continued detention is warranted, the appeals chamber recalls that in determining whether the conditions pursuant Article 60.2 of the statute had been met, a chamber must find that detention appears necessary. In this context, the appeals chamber observes that a determination shall be made concerning the possibility and not the inevitability that one of the events listed in Article 58(1)b of the statute will occur, and that it is the responsibility of the relevant chamber to weigh the evidence before it pursuant to the relevant standard. The appeals chamber notes that in its assessment of risks under Article 58(1)b of the statute, the pretrial chamber relied on this legal standard. Indeed, the pretrial chamber correctly referred to the standard that the assessment under Article 58(1)b of the statute concerns the possibility, not the inevitability, of a future occurrence. It then analyzed the material before it against this standard. Accordingly, the defense has failed to demonstrate that the pretrial chamber misapprehended the legal standard relevant to the assessment of risks under Article 58(1)b of the statute. With regard to the pretrial chamber's assessment and weighing of evidence in assessing risks pursuant Article 58(1)b, subparagraph 2 of the statute, the appeals chamber notes that the pretrial chamber made reference to 5 documents, including media articles, publications of non-governmental organizations, and a book which, in its view, indicated that Mr. Duterte's inclination to interfere with investigation against him. In relation to the first document, a media article, the appeals chamber finds that it was not unreasonable for the pretrial chamber to rely on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being directly involved in briefing individuals, it does not refer to statements of close, it does refer to statements of close associates, including one where individuals would have been told to remain loyal. In any event, the appeals chamber observes that Mr. Duterte's alleged involvement in briefing individuals is but one of the factors that the pretrial chamber took into account to support its conclusions on Mr. Duterte's inclination to interfere with investigations against him. In relation to the other 4 documents, a book, 2 publications of non-governmental organizations, and a press article, the appeals chamber recalls that there does not exist in the applicable law of the court any impediment to use of newspapers, articles, or other public or open sources for the purposes of assessing the requirement under Article 58(1) of the statute. Nor is there any requirement that such material be corroborated. Noting this, the appeals chamber considers that it is possible to discern how the pretrial chamber reached its conclusion on Mr. Duterte's alleged involvement in the threatening and taking of retaliatory actions against individuals opposed to him. In any event, the appeals chamber observes that this is only one of the factors that the pretrial chamber took into account to support its conclusion on Mr. Duterte's inclination to interfere with investigations against him, and more generally on the risk of Mr. Duterte obstructing or endangering the investigations or the court proceedings. For these reasons, the appeals chamber considers that the defense has failed to demonstrate an error in the pretrial chamber's assessment and weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b), subparagraph 2 of the statute. In relation to the pretrial chamber's reliance on the notion of a network of supporters, the appeals chamber recalls that it has considered that it is sufficient for a chamber to establish that it is possible that a suspect had the necessary assets to abscond, and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence. The appeals chamber has also held that the existence of a supportive network and financial means may be relevant to determining whether there is a risk that a person may evade justice or interfere with the investigation, and that access to the international contacts could provide the means to enable a suspect to abscond, whether or not there was evidence that the suspect would actually utilize such contacts. In the impugned decision, in determining whether Mr. Duterte posed a flight risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The appeals chamber considers that contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte, and for which reason this supported its conclusion that the risk under Article 58(1)(b), subparagraph 1 of the statute was established. In the view of the appeals chamber, the manner in which the pretrial chamber undertook this assessment was case-specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025. It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)(b), subparagraph 1 of the statute. Further, under the first ground of appeal, the defense argues that the pretrial chamber's alleged reliance on irrelevant considerations led to errors of law and fact. Regarding the arguments on the assessment of evidence, and in particular, the defense's contention that a number of factors relied on by the pretrial chamber were irrelevant, the appeals chamber notes that when assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber relied on several factors in support of its finding that such risk existed. It relied on a statement by Mr. Duterte, statements by others, Mr. Duterte's position as a former president of the Philippines and his recent re-election as mayor of Davao City, as well as the matter of the gravity of the alleged crimes and concomitant sentence in case of conviction. The appeals chamber observes that the defense does not explain why, in its view, these factors were irrelevant to the pretrial chamber's assessment. Without more, the defense has failed to substantiate that the pretrial chamber's reasoning and assessment were unreasonable. In the same vein, the defense fails to demonstrate that the pretrial chamber's reliance on Mr. Duterte's re-election as mayor of Davao City in its assessment of the risks under Article 58(1)(b), subparagraph 3 of the statute was unreasonable. Moreover, with regard to the defense's contention that the pretrial chamber selectively cited facts and ignored others in the same items of evidence, the appeals chamber considers that the defense has failed to demonstrate how the fact that the pretrial chamber accorded weight to the statement from Mr. Duterte that it cited should result in the pretrial chamber's ignoring or attaching no weight to other statements. Regarding gravity and concomitant sentences in case of conviction, it is recalled that the appeals chamber has consistently held that these factors are relevant considerations in assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, as these are factors that may increase an incentive of a person to abscond. In the present instance, the gravity of the alleged crimes and the possibility of a lengthy sentence was but one of the factors the pretrial chamber took into account in its assessment of risks under Article 58(1)(b), subparagraph 1 and 2 of the statute. And it looked at the specific allegations against Mr. Duterte. It follows that the defense has failed to demonstrate an error. Regarding the question of whether the pretrial chamber erred in fact by failing to give appropriate weight to relevant facts, specifically Mr. Duterte's health condition and its mitigating effect on the risk factors set out in Article 58(1)(b) of the statute as argued by the defense. The appeals chamber recalls that there is no provision in the court's legal texts that specifically provides for the interim or conditional release of a detained person on health grounds. Nevertheless, the appeals chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)(b) of the statute, and may be a reason for a pretrial chamber to grant interim release with conditions. The appeals chamber considers that such a determination is necessarily case-specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted the reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected. Second ground of appeal. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state warranties. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state warranties. The appeals chamber is of the view that the pretrial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58(1)(b) of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warranties. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58(1)(b) of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the appeals chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable. Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed proffered conditions in a situation such as the one at hand. It did so against the backdrop of having found that all three risks under Article 58(1)(b) of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected. Third ground of appeal. Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, it gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable. The pretrial chamber found the existence of risks under Article 58(1)(b) of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release. The pretrial chamber then proceeded to analyze whether humanitarian grounds, as argued by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed the relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected. finally, the appeals chamber notes that the pretrial chamber reached its conclusions in relation to the risks enumerated in Article 58(1)(b) of the statute on the basis of a comprehensive assessment of the information before it. In the present case, having rejected the 3 grounds of appeal presented by the defense in the appeal brief, the appeals chambers unanimously confirms the impugned decision. This brings us to the end of the summary of the appeals chamber's judgment. The judgment will be notified to the parties and participants after the hearing. Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We will.
The International Criminal Court opens today, Monday, February 23rd, the confirmation of charges hearing against former President Rodrigo Duterte. The hearing begins at 10 a.m. in The Hague or 5 p.m. in Manila before pretrial Chamber 1. This pretrial stage will determine whether the case will proceed to a full trial. Pretrial Chamber 1 is composed of presiding Judge Julia Antoanella Motoc, along with Judges Reina Adelaide Sophie Alapini Gansu and Maria del Socorro Flores Liera. Proceedings are scheduled on February 23rd, 24th, 26th, and 27th, and will be conducted in Duterte's absence after the chamber granted his request to waive his right to appear. the ICC clarified that his absence is based on a written waiver and not on health grounds. The Duterte family also announced that several Filipino lawyers who are former members of his cabinet will attend the hearing to ensure he is represented by a Filipino legal team. Among those named are former Executive Secretary Salvador Mediavdea, former LTFRB Chairman Martin Delgrad III, former Labor Secretary Silvestre Bello III, former PAGCOR President and CEO Alfredo Lim Jr., former BIR Commissioner Cesar Dulay, and former Chief Presidential Legal Counsel and PALA spokesman Salvador Panelo. The court stressed that the confirmation of charges hearing is not a trial. Judges will not rule on Duterte's guilt or innocence, but will decide whether there is sufficient evidence to establish substantial grounds that he committed the crimes charged. If the charges are confirmed, the case will move to a trial chamber. Judges will have up to 60 days after the hearings to issue their decision. During the proceedings, the prosecution, the defense, and the legal representatives of victims will present oral arguments. A total of 539 victims have been authorized to participate at this stage. Duterte faces allegations of crimes against humanity, including murder and attempted murder, in connection with the government's anti-drug campaign from 2011 to 2019. The confirmation of charges hearing marks a critical step in one of the most closely watched international cases involving a former Philippine leader.
their names. Maître Salvador Mediadea, who Your Honours are familiar with from the initial appearance, Attorney Martin Delgras, Attorney Silvestre Bello, Attorney Alfredo Lim, Attorney César Doulay, and of course, Attorney Salvador Panelo. Thank you very much.
Merci beaucoup, Maître. J'ai envie de...
Thank you very much, Counsel. I would like to now call upon the legal representatives of victims to present them, to introduce themselves and confirm to me that the list of your team members I received before is correct.
Victims participating in this proceeding are represented today by Mr. Joel Boutuyan, Mr. Gilbert Andres, myself, Paulina Massidda, and I confirm the list of our jurists who assist us today as provided to the court officer. Thank you very much.
Merci beaucoup, Maître Massidda.
Thank you very much, Maître Massidda. Thank you. On my right, I have Judge Rain Adelaide, and I have Judge Adelaide Sophie Alapina Gansu, and to my right I have Maria del Socorro Flores Liera. And I am Julia Antonuela Motok, and I am the presiding judge in Pretrial Chamber 1 of the court. This hearing concerns the confirmation of charges by the prosecution against Mr. Duterte. At this stage of pretrial proceedings, the OTP alleges that Mr. Duterte is responsible for the crimes that the court officer shall read out shortly. The Chamber shall not take any decision with regard to the guilt or innocence of Mr. Duterte during this hearing. Indeed, the role of the Chamber is to determine whether there is sufficient evidence to establish substantial grounds to believe that Mr. Duterte committed the crimes with which he is charged. If all or part of the charges are confirmed, the Chamber will refer the case to trial, where the trial chamber will decide upon the innocence or guilt of Mr. Duterte. The general principles to be applied at the hearing are as follows. The suspect, in accordance with Article 66 of the Rome Statute, the suspect is considered to be innocent until his guilt has been proven by the court. The burden of proof is upon the OTP, which must produce sufficient evidence to prove the charges against Mr. Duterte at the required standard of proof at Article 61, paragraph 7 of the Rome Statute. Finally, the defense enjoys, or the suspect enjoys, all the rights listed at Article 61, paragraphs 6 and 67 of the Rome Statute. The hearing shall take place according to the schedule contained in the order dated the 26th of January 2026, document number 359. The parties and participants must respect the allocated speaking times indicated in this order. I would like to remind the parties and participants that oral remarks must be concise and that repetition of previously presented arguments should be avoided. In addition, in order to facilitate the work of the interpreters and ensure the proper transcription of discussions, please make sure that your microphone is on every time you address the court. And please speak slowly and mark pauses between each sentence. Generally speaking, the hearing will be held in open session, and parties and participants will refrain from mentioning the names of victims and witnesses. They will only refer to them by their pseudonym or their code. In order to avoid the disclosure of any confidential information, notably with regard to witnesses and victims, the parties and participants will clearly indicate whether their submissions can be presented in public or whether they deem it necessary to move into private session, notably when referring to items of evidence. The parties and participants will clearly indicate when it is no longer necessary to remain in private session. With these rules in place, we can now move to the reading of the charges in its shortened form, indicating the charges against Mr. Duterte. The full version is available publicly on the internet site of the court. The defense has not raised any objections in this regard. I would like to remind the public that the charges that shall be read out in a few seconds comprise allegations raised by the Office of the Prosecutor that the Chamber shall analyze in order to decide whether the evidence presented by the Office of the Prosecutor is sufficient in order for these charges to be confirmed. Madam Courtroom Officer, would you please read the charges?
The prosecution charges Mr. Rodrigo Duterte with 2 counts of murder and 1 count of murder and attempted murder as a crimes against humanity committed between 2013 and around June 2016 and between around July 2016 and September 2018 in the Republic of the Philippines as follows. Count 1. Murder of 19 victims alleged to be criminals, including 3 children, who were killed in or around Davao City in the Philippines between 2013 and around 2016 by members of the Davao Death Squad, while Mr. Duterte was the mayor of the Davao City pursuant to Article 71A of the Rome Statute. Count 2. Murder of 14 victims labeled as high-value targets for their alleged criminality, who were killed in locations across the Philippines between around July 2016 and July 2017 by a network of perpetrators comprising state actors and others, referred to as the National Network, while Mr. Duterte was the President of the Philippines pursuant to Article 71A of the Rome Statute. And count 3. Murder and attempted murder of 45 victims, comprising 43 murders and 2 attempted murders of persons alleged to be criminals, including 3 children who were targeted in barangay clearance operations in locations across the Philippines between around July 2016 and September 2018 by members of the National Network, while Mr. Duterte was the President of the Philippines pursuant to Articles 71A and 25(3)(f in respect of the attempted murder of the Rome Statute. The prosecution alleges that Mr. Duterte is individually criminally responsible for all 3 of the above counts as follows. First, as an indirect co-perpetrator pursuant to Article 25(3)(a) of the Rome Statute, at least between 1st November 2011 and 16 March 2019, Mr. Duterte and his co-perpetrators shared a common plan to neutralize alleged criminals in the Philippines, including individuals perceived or alleged to be associated with drug use, sale, or production, through violent crimes including murder. Mr. Duterte and his co-perpetrators implemented this common plan through the hierarchically organized structures of the Davao City Police and Davao Death Squad, and then the national network. Within the framework of the common plan, Mr. Duterte made essential contributions to the crimes in counts 1 to 3 by A. Designing and disseminating the police to neutralize alleged criminals, both in his role as a mayor of the Davao City and also during his presidential campaign and as a president, including by endorsing the anti-illegal drugs campaign Double Barrel. B. Establishing and overseeing the DDS. C. Instructing and authorizing violent acts, including murder, to be committed against alleged criminals, including alleged drug dealers and users. D. Providing personnel and other necessary logistic resources, such as weapons, including those to be used in the execution of the crimes. E. Appointing key personnel to positions which were crucial to the execution of the crimes. F. Offering financial incentives and promotions to police officers and hitmen to kill alleged criminals. G. Creating and maintaining a system in which perpetrators knew they would be protected, including through promises of immunity and shielding perpetrators from investigation and prosecutions. H. Making public statements authorizing, condoning, and encouraging killings of alleged criminals, both as a mayor of the Davao City and as a president of the Philippines. I. Authorizing state actors to take part in the anti-drugs campaign and temporarily revoking such authorization, including to placate public outcry. J. Publicly naming individuals and holding up charts from lists of alleged criminals, including so-called high-value targets, some of whom were subsequently killed. Second, in the alternative, Mr. Duterte is charged with ordering and/or inducing the charged crimes pursuant to Article 25(3)(b) of the Rome Statute, and/or aiding and abetting these crimes pursuant to Article 25(3)(c) of the Rome Statute.
Merci, Madame la greffière.
Thank you, Madam Courtroom Officer. With regard to objections and observations under Rule 122, paragraph 3 of the Rules of Procedure and Evidence, the Chamber notes that the defense submitted a number of written observations, and the last of which was on the 16th of February 2026, to which the OTP and the legal representatives of victims responded, respectively, on the 17th and the 18th of February 2026. On the 20th of February 2026, the Chamber dismissed, in its public decision, the defence's objections. In specifying that the defense and the Office of the Prosecutor are not permitted to reiterate the same arguments already presented in the filings mentioned, that they filed to date in this case, I will now ask if the parties wish to make any oral submissions on this point before moving to the opening statements. Mr. Deputy Prosecutor? Mr. Nyang, we do not have any submissions to make in this regard. Thank you very much, Mr. Deputy Prosecutor. Counsel?
Madam President, we have no observations.
Merci beaucoup, Maître Kaufmann. Donc, on peut maintenant passer à la phase.
So we can now move on to stage 2, namely the opening statements, and I hand over to the Office of the Prosecutor. Mr. Deputy Prosecutor, please.
Madam President, honorable member of the bench, all those following these proceedings inside the courtroom and outside, and especially those in the Philippines. Today marks an important day for international justice for the people of the Philippines, for the victims, and for this court. The commencement of the confirmation hearing against Mr. Rodrigo Duterte is a reminder of the court's unwavering commitment to its mission to investigate and prosecute individuals for the most serious crimes of concern to the international community and to bring justice to the thousands of victims of the mass crimes and atrocities perpetrated in the Philippines. It is also a reminder that those in power are not above the law. Your Honors, over the course of the next 20 minutes or so, I will provide an overview of the evidence in this case that demonstrates that Mr. Duterte is responsible for the charged crimes. And my team will then develop aspects of this evidence in more details. This case before you today, it is before you today because there are substantial ground to believe that Mr. Duterte is criminally responsible for those 3 counts of murder just spelled out and attempted murder as crimes against humanity. These charged crimes were committed during the time within the court jurisdiction, which is between the 1st of November 2011 and the 16th of March 2019. At first, they were committed in and around Davao City, where Mr. Duterte was a mayor, and then expanded across the rest of the Philippines when he became president. Mr. Duterte is charged with 49 incidents of murder and attempted murder of 78 victims, including children. These murders and attempted murders were part of a widespread and systematic attack that overall resulted in the killings of thousands of civilians across the country during the relevant time frame. Thus, the charged incidents are merely a fraction of the overall criminality that resulted from Mr. Duterte's so-called war on drugs. What is Mr. Duterte's core contribution? Your Honors, Mr. Duterte played a pivotal role in the commission of the charged crimes. His contribution was essential, as he was at the very heart of the common plan to use his words, to neutralize alleged criminals in the Philippines, including through murders. The victim included individual associated with or perceived to be associated with drugs. One of the first things Mr. Duterte did when he became the mayor of Davao back in 1988 was to create the infamous Davao Death Squad, otherwise known as DDS. As you will have seen from the prosecution pre-confirmation brief, Mr. Duterte personally instructed Death Squad members that their mission was to kill criminals and suspected criminals, including drug users and dealers, also referred to as drug pushers. The death squads carried out this mission well into the charge period through 2011 to 2016, perpetrating the crimes charged in count 1. Your Honors, Mr. Duterte's criminal plan and his intent were no secret. He not only shared them with his co-perpetrators and members of the death squad, but also made them abundantly clear to the general public in the numerous public statements that he made time and again. During his presidential campaign, Mr. Duterte explicitly vowed to implement the common plan to neutralize alleged criminal nationwide if elected. This was his program to be elected. He publicly announced his intention to eradicate corruption, criminality, and drugs in 3 to 6 months. And this is what he said. I quote, "If I become the president, I will order the military and the police to hunt down the drug lords, the big ones, and kill them." That's what he said. And this can be found at tab 12 of the prosecution list of material. Similarly, when speaking about druggies, I quote, in a televised interview in 2015, this is again what he said. "If I become president, you will all get wiped out. I will order your execution within 24 hours. That's what he said. That I quote directly from his word. And this quote can be found at tab 19.2 of the prosecution list of materials, ERN PHL OTP 401684, page 003, and these are the lines 82 to 83. And elected he was. And becoming president on 13th of June 2016, this provided him with the opportunity to follow through with his promise and to expand extrajudicial killings of alleged criminals beyond Davao and across the rest of the Philippines. He did this through the implementation of the National Anti-Illegal Drug Campaign, better known as Duterte's War on Drug, and its project, Double Barrel. These were carried out by the national network consisting of law enforcement personnel working together with non-police assets and hitmen. Mr. Duterte authorized murder and personally selected some of the targets. During the mayoral period, when he was mayor, his clearance was required for the DDS to carry out the killings. Essentially, members of the DDS needed Mr. Duterte's green light to murder. And during the presidential period, Mr. Duterte has continued to personally identify some of the targets, including by publicly naming those he claimed were involved in illegal drug trade or in other forms of criminality. He also identified targets by holding up a list containing their name. And if you are on the list, you will be killed. And this was a word of one prosecution witness. And this evidence can be found at tab 54 of the prosecution list of materials, ERN PHL OTP 00015 page 0009, and the relevant lines are 260 to 261. Mr. Duterte provided moral and financial support to the direct perpetrators as well. In a 12 December 2016 speech, Mr. Duterte admitted that he used to ride around Davao on a motorcycle looking for trouble, so he could kill. And he said, and this again his own word I'm quoting here, in Davao, I used to do it personally, just to show the guy that if I can do it, why can't you? And these are his own words. And this quote can be found at tab 16.1 of the prosecution list of material, ERN PHL OTP 0001547 at 0002 lines 7 and 8. And the evidence show that Mr. Duterte's Davao City Mayor office provided some member of the DDS with a regular salary. Financial rewards were also given to direct perpetrators in the form of cash per head of killing. And at a press conference in 2013, Mr. Duterte stated that shoot to kill orders and reward are, and I quote him, are legitimate tools of government to fight lawlessness. This is his own word. And if he surrendered to me or his carcass dead, then I double the price. And again, yeah, and that was what he boasted. This quote can be found at tab 17.2 of the prosecution list of materials, PHL OTP 000094932 at 0002, and the relevant lines are lines 7 to 11. Deaths of drug personalities killed in anti-drug operation were endorsed by Mr. Duterte's administration and listed as official accomplishment in public reporting. Your Honors, as you will have reconfirmation brief, Mr. Duterte also provided the direct perpetrators with weapons, ammunition, and logistical support to facilitate the commission of the charged crime. And he also had control, wide control over those crimes. And let me now turn specifically to that control. As mayor of Davao and later as president of the Philippines, Mr. Duterte wielded ultimate influence and authority over the physical perpetrators of the crimes. As mayor, Mr. Duterte was chief executive of the Davao city government, with responsibility for exercising general supervision and control over all its activities. He had formal operational supervision and control over National Police Unit in Davao. As creator and head of the DDS, he also had de facto control over the death squad's members. When Mr. Duterte became president on the 30th of June 2016, he sat at the very apex of the political power structure in the Philippines. He became the head of state, head of government, and commander-in-chief of all armed forces of the Philippines. He also became the leader of the country's police forces. This level of authority allowed him to wield de jure and de facto control over those implementing the common plan nationwide. Mr. Duterte's control over the crime is also apparent from his ability to interrupt their commission when he so chooses. And as outlined in our reconfirmation brief, he successfully suspended police anti-illegal drug operation on 2 occasions following public outcries in response to particularly notorious killings. On both occasions, the number of reported killings dropped significantly during the suspension, showcasing his control. So when he asks people to act, they act. When he asks them to refrain, they do so. So they oblige. So Mr. Duterte was well aware of the authority he had over the perpetrators. In a speech given to the National Bureau of Investigation in November 2016, he expressly acknowledged his position of power. And this is what he said. To the military, I am commander-in-chief. On the civilian side, I am the chief executive of the government. And when talking about the police, this is what he's saying. They are my subordinate, and I am ultimately responsible for their deeds. And these are quotations, and they can be found at tab 131.2 of our prosecution list of materials at ERN PHL-OTP-00095-679, page 0004, and the relevant lines are from 131 to 134. And the direct perpetrators complied with Duterte's order and respected his authority. Mr. Duterte was respected by the physical perpetrators. He was feared, and his order and instruction were obeyed. One insider witness explicitly says that the police killed, and I quote, because of the directive of the president. This is what the witness said, an insider. And this quote can be found at tab 120 of the prosecution list of material, ERN PHL OTP-00088-631- R01 and page 66, and the relevant line are from 2304 to 2306. And this statement is corroborated by other statements we have also provided. And some direct perpetrator complied because of their blind loyalty to Mr. Duterte. Some did it out of fear, and others were encouraged to comply by promises of money and rewards. For some, killings reached the level of a perverse form of competition with effort to attain killing quotas, which in turn would lead to promotions and rewards. Others felt there was no other choice but to comply, with one insider explaining that it was simply not possible to not obey Mr. Duterte's command. And this is also from an insider witness. And this evidence can be found at tab 51 of the prosecution list of materials, ERN PHL-OTP-001-5403 at page 0008 to 0009, and the relevant line here is from 240 to 245. Direct perpetrators were further emboldened to commit crime by Mr. Duterte's repeated promises of immunity. In various public statements, Mr. Duterte vowed to protect the police involved in killing. And this is what he said again. For as long as there is a power to pardon in the Constitution, that's my weapon against crime. If you massacre 100 and there are 100 of you, then you will all be pardoned. Restored to full political and civil rights, plus a promotion to boot. It's like that, especially the high profile. And this quote can be found at tab 130.2 of the prosecution list of materials at ERN PHL-OTP and 50336 at page 0010. Such statements reassure the physical perpetrators. One insider described that he felt confident to continue killing people because he knew that he wouldn't be arrested for that. And this evidence can be found at tab 38 of the prosecution list of material, ERN PHL-OTP-0001-2779 at page 0005, and relevant lines are from 130 to 131. Your Honors, let me now say a few words about just the contextual elements. The 78 murders and attempted murders that Mr. Duterte is charged with, in this case, were not random. These were not random crimes. Nor was they spontaneous or happened in isolation. Rather, the evidence demonstrates that they were part of a widespread and systematic attack directed against the civilians population of the Philippines. The murders and attempted murders were carried out across the Philippines and over a substantial period of time. Overall, Duterte's so-called war on drugs resulted in the killings of thousands of civilians from the 1st of November 2011 to the 16th of March 2019. And many of these victims were...
Excuse me, Counsel, you have 5 minutes left.
Okay. Yes, were children. The victim of extrajudicial killing charge in this case were brutally murdered, some after having been abducted and mistreated. Unlike Mr. Duterte, who is represented by his counsel here today, they were deprived of any form of due process. The loss of every single one of these victims had the most profound impact on their families, their friends, and ultimately their communities. Their suffering was met not merely with Mr. Duterte's indifference, but with his mocking. In a 25 July 2016 speech, he expressly made fun of the iconic photograph portraying the partner of an extrajudicial killing victim cradling his body, which now visible on our screen. While the specific incident portrayed in this photograph is not charged in this case, Mr. Duterte's comment on it is demonstrative of his attitude towards the victims. In reference to this photo, Mr. Duterte, this is what he said. Those of you who are still sober, those who haven't tried illegal drugs, if you don't want to die or get hurt, don't rely on the priest, including human rights advocate. They won't be able to prevent death. So, don't do it. And then, there you are, sprawled on the ground, and you are portrayed in a broadsheet like Mother Mary cradling the dead cadaver of Jesus Christ. That's how they are creating dramas here. This is what he said. And this quote can be found at tab 128 of the prosecution list of material at ERN PHL-OTP-50335, page 0008. And of course, the question of whether Mr. Duterte had knowledge and intent, of course, it goes without saying. Your Honors, Mr. Duterte intended and knew that the charged crime were occurring, or that they would occur in the ordinary course of events that he had set in place and put in motion. His intent and knowledge are shown by the multiple statements he made throughout his mayoral and presidential tenure, promising to reduce crimes by killing alleged criminals, promoting the common plan, and urging police and even members of the public to kill alleged criminals. As detailed in the prosecution pre-confirmation brief, and as Your Honor will hear in the course of my team's presentation, Mr. Duterte also made statements directly acknowledging allegation of extrajudicial killings by his subordinates and issued written order showing he knew about the crimes they committed. Your Honors, the prosecution relies on significant and varied sources of evidence to demonstrate that substantial ground exists to believe that Mr. Duterte is criminally responsible for the crimes. This evidence includes multiple witness statements, including insider witnesses. It includes many speeches of Mr. Duterte himself, as well as the statement of his co-perpetrators, It also includes orders and other documents signed by himself. The prosecution further relies on official government documents, including material from the Philippine National Police. It relies on drug watch lists, on audio and video material, as well as on forensic and financial evidence. Your Honors, during the prosecution's subsequent presentation, my colleague will elaborate on some of these core evidence in more detail. Mr. Nichols will give a presentation on Mr. Duterte's background, followed by an overview of the evidence demonstrating his responsibility for the crime charged in count 1. This will be followed by the presentation of Mr. Jeremy behind me, who will speak about the evidence demonstrating Mr. Duterte's responsibility as President for the crime charged in count 2 and 3. And Ms. Croft, on my left, will then elaborate on the contextual element of crime against humanity and the mode of liability through which Mr. Duterte is responsible for the crimes alleged in this case. And to conclude, Madam President, Your Honor, while this court cannot reunite victims with their loved one, it can help reveal the truth about what happened to them and bring a sense of justice to the victim. The charge before you today are serious, and the evidence submitted require their confirmation. And Mr. Duterte must be held to account, and this case should be confirmed for trial. I thank you very much.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Deputy Prosecutor. Now we are slightly in advance on our schedule. I will now hand over to the legal representative of victims for her opening statements until 11, and then after that you shall continue. Please proceed, ma'am.
Madam President, Your Honors, by way of an opening statement, we convey the views and concerns of the 497 victims authorized to participate in these proceedings. At the outset, Your Honors, we communicate the very deep disappointment of the victims at the decision allowing Rodrigo Duterte not to be present in this stage of confirmation of charges. The sight of Mr. Duterte being read and being confronted with the grave and horrible charges against him would have constituted a vital component of justice for the victims. This case symbolically represents the last boat that the victims can board to go on a journey in search of justice for their loved ones who were brutally killed upon the orders of Mr. Duterte. If this chamber prevents the boat from sailing by not confirming the charges, the victims will forever be moored in an island where the nights are filled with the screams and cries of their massacred loved ones. There is absolutely no other recourse for the victims. No less than former Philippine Justice Secretary Crispin Remulla admitted just a few months ago that the door to domestic justice is permanently closed for victims of the Duterte extrajudicial killings. Remulla declared, and we quote, "It is difficult to prove the case here and build up the case because those who need to speak are involved in the crime. There's nothing, not even a police report. You don't have a scene of the crime, you don't have ballistics, you don't have DNA." Remulla further declared, and I quote, "Everything that could be erased was erased, so that the cases would not push through. That is why this has reached the ICC. Under the Philippine justice system, Your Honors, no criminal case can reach the courts unless they are initiated and filed by the Department of Justice or the Office of the Ombudsman. From Justice Secretary, Remulla has been appointed as Ombudsman. So the two gatekeepers of justice are successively occupied by a ranking official who has declared that there is absolutely no hope for domestic justice for the victims. If the charges are not confirmed in this case, one of the gravest concerns of the victims is that Mr. Duterte will return to the Philippines as a conquering hero. He will resume preaching his gospel of impunity. In fact, if Mr. Duterte could threaten to slap the judges of this court, which he did while he was president, this chamber should imagine the kind of terror-filled threats and the violent actions that can easily be used against the victims if the suspect walks free from this court. If the charges are not confirmed, it is a very serious concern of the victims that Mr. Duterte will be portrayed in history by his multitude of followers as the leader who vanquished the ICC and who cleansed his country of 30,000 rapists, murderers, and dangerous criminals, which were the scornful words he sweepingly used against all those who were killed in his murderous spree. Your Honors, Mr. Duterte has been in detention here in The Hague for almost a year now, but there has been no peace and rest for the victims. From the time their loved ones were killed and continuously up to this time, they lived in constant fear for their lives. The arrest and detention of Mr. Duterte has not stopped impunity in the Philippines. The virus of impunity that he spread all over the country has become a cancer that has metastasized, infecting millions of Filipinos. Mr. Duterte has created clones of himself. He converted millions of peace-loving citizens into bloodthirsty disciples who have become converts to the belief that violence and killings are valid solutions to societal problems.